Cable television, are we ready?
Yes, sir, we are.
Oh, good morning. Well, then I'm gonna get started.
Yes, sir.
Thank you. I am calling to order this hearing. This is a hearing of the Committee of the Whole of the Council of the District of Columbia. I am Phil Mendelson, Chairman of the Council and Chair of the Committee of the Whole. Today is Friday, September 30th, 2022. The time is 11:20 in the morning. And the subject of this morning's hearing is consideration of two bills, Bill 24-201, entitled the Construction Management Agreement Amendment Act of 2021, and Bill 24-924, entitled the Protecting Adjacent and Adjoining Property Owners from Construction Damage Amendment Act of 2022. Bill 24-201 was introduced by Councilmember Allen and myself and several other council members on April 1st, 2021. The purpose of Bill 24-201 is to require certain applicants for a construction permit, I might say most applicants for a construction permit, or maybe many applicants for a construction permit, to enter into a voluntary or standard construction management agreement with impacted property owners. I think technically it's with the chief building official at the Department of Buildings. The purpose of Bill 24-924, which was introduced by me at the request of the mayor on July 5th of this year. The purpose is to require property owners, contractors, and other persons applying for a permit for construction work to obtain liability insurance to cover any loss or damage to adjacent or adjoining properties arising out of the construction work. Obviously, both of these bills deal with the building code and with construction and with how to best handle damage that too often occurs to abutting or nearby properties. The record in this matter will be open for 2 weeks. It will close at 5 p.m. on Friday, October 14th, 2022. We have a record that we have to file with the secretary on each bill on which we have a hearing, and we have to have a cutoff date, which is not to say that I won't consider any comments we receive after that, but they will probably not be submitted for the record. We have a number of witnesses. I'm going to call them and let them all in at once. Following the witnesses, we'll hear from the director of Today DCRA, Ernest Charapa. So the witnesses, and I will hear them in this order. The witnesses are Randall Brandt, who's a resident and property owner in the district, Liz DeBarros, who is Chief Executive Officer of the District of Columbia Building Industry Association, Eric Jones, who's Vice President of Government Affairs with the Apartment and Office Building Association of Metropolitan Washington, Francis O'Brien, who is with the American Property Casualty Insurers Association, Robert Hildum, who is just listed as a witness, Martin Burlingame, who's with 180 Intermediaries, Stephen Hoffman, who is owner of Claims Restoration, Amy Fisher, who is co-owner of Realty Group, Inc., and Thomas Glassick, who is Executive Director of the District of Columbia Insurance Federation. The witness list asks that, or states that testimony is limited to 4 minutes. We will have a 4-minute clock going. I may not cut folks off exactly at 4 minutes, but please be mindful of the clock. If you're in gallery view, you will see the timer, I believe, in the top row. Is Mr. Brandt here? Because you will be first. And I appreciate you submitted your testimony early, and I looked through it, read it this morning. It's a bit long for 4 minutes, so you'll have to summarize it. Mr. Brandt?
Yes, Chairman Mendelson, can you hear me?
I can hear you. I can't see you.
Okay.
I can see you.
Thank you, Chairman Mendelson. Really appreciate the chance to speak with you and the council today. I also want to thank you and Council Member Allen in particular for your leadership in this hearing. Basically, I just want to highlight a few things from the written testimony that you referenced that have impacted our family over the last number of years. Just take any questions that anyone has. So first of all, the reality is there are some things in life that are bigger deal than this, and life is short, and I want to acknowledge that, thinking of the folks in Florida right now. But the big picture point I want to make is based on our experience with two large developers, there are no meaningful protections now for adjacent residents and homeowners other than those provided by human decency, general tort law, or whatever provisions ANCs are able to negotiate. We found in our own experience that human decency was a little thin at the top levels of the two developers we have experienced. Tort law is a late and blunt instrument when the real goal should be to prevent damage and mitigate negative construction impacts on neighboring residences. Moreover, beyond the obvious and significant equity issues, most people don't have the time, energy, or resources to sue large developers that are negligent and indifferent or callous toward how they are negatively impacting existing adjacent residents. Many ANC volunteer leaders do their best to help, but they're usually not structural or civil engineers, hydrologists, or construction lawyers, etc. Also, in our experience, the developers view the ANC conditions as suggestions whenever they want to. I want to particularly highlight the noise ordinance issues. The DC construction ordinance, which is supposed to prevent construction noise before 7 a.m., is often artfully avoided by developers. Most egregious for residents and families is construction work related to these large construction projects like a VEC at 8th Street Northeast in our case. This is done throughout the night for days and sometimes weeks at a time without compensating the immediately adjacent residents for the inability to sleep in their own home. I did briefly get to see some of the DCRA testimony, and I find it confusing, to be honest, based on our experience on 3 points in particular. And our home was 6 inches from this large 2-block construction project. So vibration monitoring is industry practice. And so when you are immediately adjacent to a large project, there's no confusion about whether you need vibration monitoring to protect your home. The second thing is the night work issue. When a permit is given for night work, and you know the nature of that work, it's not complicated to come up with a mechanism so that families who don't want to lose sleep all night can be compensated for their lack of sleep and lack of ability to use their residence. And then the comments, thirdly, on comments about mediation. I've been a mediator. I had the privilege of being a mediator in DC for 12 years. I've resolved hundreds of cases with neighbors and residents throughout the city. And mediation is not required in these cases unless you sue. That's when mediation is required. I do agree that good practice in construction law and construction in general, they were the pioneers in arbitration and mediation provisions, dispute resolution provisions. In our case, neither developer had any interest in such a thing. And that's why the construction management amendment is so critical. I commend the mayor for the proposal for the insurance coverage. I think they're a great companion together, but our experience does not match what is being described. But I want to appreciate the chance to be here, a chance to speak with you, and thank you for your leadership in this area. I welcome the opportunity to speak with any members of the council personally or their staff. Thank you again for your time.
Mr. Barrows.
Good morning, Chairman Mendelson, members of the Committee of the Whole and staff. Good morning, Councilmember Allen. My name is Liz DeBarros. I'm the CEO of DCBIA. I'm also a longtime resident of Ward 7. DCBIA is the leading voice of real estate development in the District of Columbia. Thank you for the opportunity to testify in these two bills. We're also submitting detailed written testimony to the committee, but in my time this morning, first I'd like to address the Construction Management Agreement Act. While we support the intent of this bill, we believe it lacks clear language regarding reimbursements, affords the ANC power beyond great weight standard, and imposes penalties without finding of guilt. As to the standard agreements, they would require a covered applicant to reimburse an impacted property owner for engineering expenses authorized by the building code official. The language is vague as to whether the covered applicant is subject to reimbursement of the full value or fair market value, since impacted property owners could take advantage of this reimbursement by expending a more costly construction project or pocketing the amount without engaging an engineer. There must be a limit on the extent to which they are reimbursed and the policing of that reimbursement so that is used as intended. Moreover, as written, the legislation only requires notice of incurred expenses. However, the impacted property owner should be required to send more information to substantiate his or her claim for reimbursement, but including but not limited to the actual receipt of expenses incurred. That said, covered applicants should be entitled a process in which they can dispute the amount of reimbursement if the expense clearly exceeds the reasonable price for services performed. These contentions are equally relevant to the provision that requires covered applicants to reimburse impacted property owners for hotel stays under certain circumstances as well. Next, the standard agreement requires covered applicants to not seek a public space permit that will impact parking for a public space for more than 4 weeks unless the covered applicant has received ANC approval. This clearly goes beyond the great weight standard afforded to ANCs. The covered applicant is prohibited from seeking a specific permit as a direct result of ANC disapproval, given ANC determinations full force contrary to what they are afforded by law. Since this legislation requires the covered applicant to enter into such agreement to obtain a permit covered by the construction code, this means an individual is entirely prohibited from obtaining a public space permit of the sort at the full discretion of an ANC. Finally, Section 8A empowers the mayor to deny a building permit to an applicant for a period of 3 years after receipt of 3 or more stop work orders in a 12-month period. This penalty should remain only if the language is amended to apply exclusively to instances where the applicant is found guilty of the offense that warrants the stop work order. The legislation does not account for any stop work orders that are challenged, but rather focuses solely on receipt, regardless of whether it was a valid, properly issued stop work order. Therefore, to achieve the purpose intended by the legislation, the provision should be amended accordingly. Now I'd like to address the concerns of the Protecting Adjacent and Adjoining Property Owners from Construction Damage Amendment Act. While we recognize the value of this bill to property owners, we believe it contains numerous ambiguities and makes developers, especially smaller ones, particularly hesitant to take on projects because of the potential scope of liability. As you can well imagine, unless a full inspection of abutting and adjacent properties, which needs to be properly defined in the legislation, is allowed, it will make insurance premiums for such policies extremely high, if not cost prohibitive, as insurance providers will not know the current conditions of these properties. That said, we would specifically like to have the language make clear that any claim being brought must be brought by a property owner within a certain foot threshold of the construction, has allowed the insurance inspectors the right to inspect their property both inside and out, and that this covered under standard liability insurance products already in existence and not a new form of insurance, or under builder risk insurance, which would cause immediate work stoppage, as no construction project would be able to cover that cost. Additionally, it should be made clear that the additional insureds on the plans are not to include adjacent or adjoining property owners. Insofar as the mayor is to specify the amount of the insurance rule, we urge further consideration on this point, as there is no indication as to the amount for developers to fairly judge whether the passage of this bill would prohibit them from taking down projects in the district. Without defining adjacent and adjoining property owners, permitting developers the right to inspect the properties for which they are responsible for insuring, and clarifying that this bill falls under the standard liability insurance. Developers will be and have expressed to us that they would be extremely cautious of taking on projects with this potential scope of liability. Thank you for the opportunity to testify. We'd like to work with you to amend these legislations if they were to move forward, as many of my members are very concerned about the pieces of legislation and how they would affect their current and future projects. We currently have a small working task force regarding the legislation, and we're happy to meet with you and your staff regarding concerns, which I have stated in my testimony. I'm happy to answer any questions.
Thank you, Mr. Barros. Eric Tillman.
Good morning, Chairman Mendelson and the members of the Committee of the Whole. My name is Eric J. Jones, and I'm Vice President of Government Affairs for the Apartment Office Building Association, Metropolitan Washington, also known as AOBA. I'm here today to provide comments on B24-201, Construction Management Agreement Amendment Act of 2021, and B24-924, the Protecting Adjacent and Adjoining Property Owners from Construction Damages Amendment Act of 2022. B24-201, Construction Management Amendment Act of 2021. As an organization, AOBA has a great deal of concerns with the legislation as introduced, as we believe that it's extremely vague. We would like to raise 4 particular issues. Number 1, the standard agreement. Within the legislation, it stipulates that impacted parties are to consider the use of a standard agreement in negotiations. Unfortunately, legislation fails to identify who will design the standard agreement, lay out the mandatory language required in the standard agreement, and more importantly, it fails to stipulate that the standard agreement is to serve as the baseline for negotiations. Number 2, construction monitoring agreements. Current best practices within the industry require that installation of monitors in addition to clearly defined threshold levels. Within the legislation, however, there is no explanation of how the mayor or her designee will set the thresholds required for monitoring, including but not limited to vibration. Moreover, there isn't detailed language on what the monitoring will identify or mutually agreed upon remedy. Number 3, proof of impact. As the legislation currently reads, upon receiving the project notice, the adjacent and/or adjoining property owner is required to obtain an engineering report. As opposed to following the guidelines of the report, the permit applicant is then required to enter into an agreement irrespective of if the report stipulates that the adjacent and/or adjoining properties are likely to be impacted by the proposed project. Number 4, impact of the Advisory Neighborhood Commission. ANCs, like the council, are political bodies which are subject to personal, professional, and/or political disagreements. Within the legislation, it stipulates that the application for extended parking provisions must be accompanied by an approved resolution from the entire ANC, as opposed to the commissioner whose SMD the impacted location resides in. ANC meetings are less frequent and in some instances may be delayed due to no fault of the applicant. If the commission is unable to take a vote on a pending month, a project can be delayed by as many as 4 to 8 weeks before obtaining approval due to no fault of the applicant. B24-9-24, Protecting Adjacent and Adjoining Property Owners from Construction Damages Amendment Act. While AOBA has some concerns with this legislation, we feel that our broader membership is overwhelmingly covered by current insurance held, and for that reason, we believe this law is unneeded. In closing, I thank you for the opportunity to testify and willing to answer any questions you may have.
Thank you, Mr. Jones. Francis O'Brien.
Thank you, Mr. Chairman, and thank you to the members of the council and staff. For the record, my name is Frank O'Brien. I am Vice President, State Government Relations for the American Property Casualty Insurance Association. I'm appearing before the council today as a substitute for my colleague, Nancy Egan. Nancy is normally the one who would handle issues in the district, but Nancy unfortunately has a conflict today. APCIA is a national property casualty trade association comprised of over 1,000 member companies. Together, our members write a wide variety of commercial and personal insurance products, and as a whole, provide upwards of 70% of the insurance coverage available in the district. I'm here to testify regarding Bill 24-0924. We thank the council and the chair for their leadership on this particular issue. and for the administration in its efforts in this area as well. Mr. Chairman, the insurance market is now responding to the need that has come about as a result of discussions associated with this issue. And it is our understanding that there are several companies that are now or soon will be providing a product which will meet the needs of the marketplace in this area. For this reason, APCIA is generally neutral on the bill's main provisions that would mandate insurance coverage in order to get a permit. We look forward to working with interested stakeholders on this issue, and we would be especially interested in the DCIF, the District Insurance Commissioner, be included in the mechanisms that would be put in place to provide a framework in the associated regulations or other requirements that would be needed to provide the working mechanisms for this bill. With that, Mr. Chairman, I'd be happy to answer any questions.
Thank you, Mr. O'Brien. I don't have a copy of your statement.
We have not submitted a written statement. We will be doing so within the 2 weeks that you have set forth, Mr. Chairman.
Excellent. That would be very, very, very helpful. Thank you. Robert Hildum. Is Mr. Hildum here?
I am. There I am.
Please proceed.
Good morning, sir. I have not submitted my testimony yet. It's written and I expect to have it this afternoon with pictures. Good morning, Chairman Mendelson and Councilmember Allen. My name is Rob Hildum and I've lived in the District of Columbia for 20 years. I live in a row house in Ward 4 with my wife and 9.5-year-old son. We bought our house in 2010 and it was built in 1915. We share common walls with our neighbors on both sides and we love everything about our house and our neighborhood, as well as the District of Columbia. We appreciate the construction management agreement amendment as a necessary and good beginning. However, as currently written, does not apply to us, owners of single-family row houses. Some of the provisions in the bill might have provided some protections to us had they been in place previously this year. No one should have to go through what we have gone through the past 9 months and continue to endure. The row house next to ours, 4505 15th Street Northwest, had been neglected for decades and was in desperate need of renovation. In 2021, it was bought at auction by a developer from Florida who incorporated in the district shortly before the purchase. We welcomed any renovation and development of the property, and unfortunately, the developer would prove to be not only dishonest, but incompetent as well. At first, his plan was to replace the kitchen and merely paint. Given the long deterioration and rundown condition of the property, this was simply ridiculous. Eventually, he accepted that he would have to do a full renovation. He obtained permits from DCRA for interior renovations and went to work. A large dumpster was rented and work began. The developer did not tent the house in any way or attempt to limit the dirt, garbage, and debris that came from the house. The entire block was covered in dirt and dust for several weeks. We had to tell him that he had to, at the very least, put a tarp over the dumpster at night to keep garbage from blowing around the neighborhood. We were all at home during this time. My wife and I were working from home and my son was attending school remotely. The noise was difficult, but we accepted it as a necessary part of the renovation. Several weeks after he started work, we received neighbor notification, which consisted of a schematic drawing showing some new wiring, plumbing, and HVAC. There were no architectural plans or any specific of any kind. Saturday, January 15th, 2022 was particularly loud, but again, we accepted it as part of the renovation. And I see my time is running down and I fear I'm going to take a little bit longer than this. So let me just tell you, he blew out the back wall of the row house, which was a violation of the permit. And then he destroyed the common wall between our home and his, and he exposed the insulation and the framing of our wall and left us with only the sheetrock between us and the elements. When we told him that he needed to do something about that, he became belligerent and told us that we didn't understand his business. He started hammering up some plywood, and again, it was really loud. He was screaming and yelling the whole time. And then when I went to my kitchen, I observed that he had put a hammer through the wall. I called the police, but by the time they came, and I did a report, by the time they came, he was gone. My wife and I hit the phones. For the next 2 days, we called everybody and anybody, our council member, everyone. We were we were directed to a consultant who we hired. After every phone call we could think of, on Tuesday, January 18th, the DCRA inspector came out and put up a stop order because he exceeded the original permit and he breached our wall. The wall cost $15,000 to repair. We naively thought that that would be the end of it, that he would have to fix the permit. He was given another permit in March by DCRA, even though there was a stop order in place, so that he could replace the, and I see my time's running out. I ask for your indulgence. I only expect 3 more minutes.
I can't give you 3 more minutes. If you could just
Okay.
wrap up now.
I'm sorry?
I can't give you 3 more minutes. If you could wrap up now, and we will get your statement when you submit it.
Okay, 3 stop orders later, we believe that he's breached the foundation of our home. We have no way to determine that because we can't get in. He has abandoned the project and the house now sits open. Windows are open, the back wall is still open. The wall we repaired is still exposed to the elements. These bills don't go nearly far enough to protect homeowners. What he has done is absolutely disastrous. DCRA has issued a blighted property citation on September 16th. Nothing's been done. Winter's coming and all the windows are open and the property's unsecured. Water is pouring into the basement that is now dirt. He owes $38,000 in property taxes. And we have spent almost $30,000 of our money after we refinanced our house to pay a lawyer, an architect, and a consultant. And this is shameful. And the District of Columbia needs to protect its residents better than it is now. And I share Mr. Brandt's comments about human decency. It doesn't exist in this particular situation. Thank you.
Thank you, Mr. Hildem. And you said you will be submitting your statement, correct?
Yes, sir, I will. And I appreciate the extra couple of minutes. Thank you, sir.
And the address of the property next door, do you know it?
4505 15th Street Northwest.
Thank you.
Thank you, sir.
Martin Burlingame? I believe he's not here. Stephen Hoffman? I believe he's not here. Amy Fisher? Please proceed.
Good morning. Thank you for having me.
I cannot hear you.
Great. I don't know how to do this.
Now you're muted. Do you have any?
There we go. There we go.
I don't know.
Can you hear me now?
You're very, very, very faint.
I'll
Right.
shout. It's my computer. I'll have to shout. Can you hear me now?
Not much better, but please shout and be close to your microphone.
Okay, here I am. Thank you for having me. I've previously submitted testimony and suggestions about the neighbor notice. I've updated it and provided it in writing along with this brief testimony. I think this is a great legislation. I'm wholeheartedly behind it. However, it addresses perhaps items H and I and an alphabet soup of issues faced by the adjoining homeowners. I believe this legislation is far too narrow and the entire process needs to be reevaluated, starting with raised permits and the neighbor notice. The DCRA issues raised permits without the need for new plans and permits to be in place, thereby exposing the adjacent homeowners' interior walls to the elements for months or years on end, with only slapping plastic to protect them. Here's a picture of our house. The developer has been telling us they expected to have approved plans in since January. We're now headed into winter again. The only way we kept warm last winter was to leave the oven on for hours on end to warm that wall. Otherwise, it radiated the chill back into the house. Heating for these row houses was designed to keep exterior walls warm. Our north wall was never an exterior wall. We have two tiny radiators on that wall and blessedly a stove. We added an electric heater in the basement. Our heating bill was 30% higher last year. The developer who has the two properties to our south side also has a raised permit in place, and we have no radiators on that wall. They could raise that property at any time, and they too have no approved plan. We have zero radiators on that wall. As for the neighbor notice, it provides homeowners access to building plans when available, and a copy of the DC Housing Code, and gives them 30 days to present undefined technical objections to DCRA. The process after that is a complete black box. We submitted no fewer than 6 sets of objections and proposed construction management agreement, all of which centered around our not wanting our interior walls exposed to the elements without plans and permits in place. This is what we got. Go ahead and pass this legislation. It will help address problems that you probably hear a lot about, but the scope of the problem adjacent homeowners face is way bigger than just parking and noise. As for the insurance portion of the bill, it seems too vague, especially when a developer is allowed to raise and attach property without permits in place to build. Thank you for your time. Sorry, I had to shout.
I'm sorry you had to shout as well, and as I said, we could barely hear you, but fortunately, I do have your written statement. The house next door, what's the address?
On one side, it's 429 and previously 431 13th Street Northeast. And the remaining derelict houses on the other side are 425 and 423 13th Street.
So is 431 the house that was raised?
429 and 431 are the properties that were raised next door to us in the city.
I'm not hearing you well, but my question is the house that was raised,
429 and 431, there are two houses.
429, 431.
which is the house adjacent to you?
429.
Thank you.
Thank you.
Thomas Glassick?
Good morning, Mr. Chairman. It is still morning. Yes. Good morning, Mr. Chairman, members of the committee. My name is Tom Glassick. I am the newly installed executive director of the DC Insurance Federation. I'm sure you, I know you both fondly remember my predecessor, Wayne McGowan, who is still with us and watching us right now from his retirement place in North Carolina. So he is actively involved and has been helping the DCI. As you know, DCIF represents the overall majority, and through our members, certainly our national trade members, including Frank O'Brien, a good friend of mine, we really do represent almost all of the insurance that is sold in the District of Columbia. As Frank shared, not necessarily strong concerns about the legislation. This is a very unique line of business that is growing. Our concerns, to the extent to which there are concerns, it has to do with the involvement of. So we would like, and DCRA has been tremendously helpful. They reached out to DISB in the spring. I have spoken to DISB about this. They reached out to me. So I anticipate that the implementation process will also be collaborative, and DISB will be involved in the development of these insurance requirements. I don't want to belabor the points too much and make sure I haven't forgotten anything I was supposed to tell you. But there are concerns related to, mandating insurance is not something that most of our member companies are comfortable with doing. So we just ask that the District of Columbia, as necessary to achieve the legislative goal. And we look forward to working with DCRA and DISB going forward. And I'm happy to take your questions.
Thank you, Mr. Glasser. We don't have a copy of your statement, and that would be very helpful.
Absolutely.
Thank you. And your connection is very unstable, so you kept breaking up while you were speaking. Let me ask a few questions. Mr. Brandt, if you're still here, could you briefly explain the damage to your house?
Yes, Chairman, thank you for the question. It's a range of things. Some of it is vibration damage for tile damage in bathrooms and kitchen. We had a extended period of time where rodents were not being addressed on the property, so we had some rodent damage issue. At one point, they were so close to our property digging that they actually dug under the foundation of our property. So there's a wide range. On the day of construction demolition, they had agreed in advance to have a protective fence, which they did not have. And then there was an exciting process involved with that. And even after construction, there was trespassing on a rear private alley, which I share with some of my other neighbors, with heavy equipment damaging the concrete without permission to be there. As they were trying to give a benefit to, if you're familiar with the area, there's a great senior affordable housing building called Capitol Hill Towers. And they had shared some of their property with these developers during the construction period. So they were building a fence as sort of a benefit for Capitol Hill Towers. So that's a long answer to a short question, but there's a lot of other issues, but those are some of the highlights. And most of them were all avoidable and preventable, but we did not have partners who wanted to be proactively addressing the issues. And that's why the construction management amendment is so critical. They refused to sit down. We actually, ironically, we took the Rappaport folks to a Ben's Chili Bowl location on 10th Street, had lunch with them, shared our concerns as we were getting up to speed about construction impacts, had about 6 or 7 proposals. They all thought they were reasonable, but when it got up the food chain, none of them were agreed to. And it took us 6 months working with the ANC to get vibration monitoring in our home.
Thank you. Mr. Hildem, I'm in a little bit of a disadvantage because I don't have a copy of your statement, but your problem, if I remember correctly, was also the an exposed and damaged party wall, as well as other problems.
Yes, sir.
But they didn't go under your foundation.
We don't know that. We think they have. He spoke with our team, consisting of my lawyer, architect, and DCRA consultant, and they got the impression he had no clue that he had any understanding at all that he was breaching the foundation. And they even spoke to his structural engineer briefly, who didn't seem to understand that they were close to the foundation. We were able to stop him, but we currently don't know the condition of the foundation. There's no underpinning at all, which our architect believes is essential. And because of what he's done to the property, every time it rains, water pours into the dirt basement, which could be further undermining our foundation.
Pours into his dirt basement.
Into his basement, but it adjoins ours. And if water is getting into the basement, it could be undermining the foundation altogether.
Sure. And Ms. Fisher, the issue with your house is not digging under your house, but just exposing, I don't want to sound like I'm minimizing this, exposing the exterior or party wall.
It's exposing the party wall, but because there's no swale there, water, like the previous gentleman, is sitting next to the property and thereby potentially undermining what was once a party wall.
Yes, and I must say your voice is returned.
I figured out what the trick was. Sorry.
Thank you. Mr. Barrows, I had a question for you. I had a question for you concerning the stop work orders. Actually, I had a couple of questions. I get that people are not guilty until, are presumed innocent until they're proven guilty. On the other hand, the process, as you know, for going through any appeals of a stop work order for any kind of an infraction can be months, if not years. And that doesn't help us here. You didn't like the idea of going from 5 to 3, I believe. But how many stop work orders should somebody get before we recognize that there's a problem with that property?
That's a good question, and I'll say up front that, DCBI, we're not trying to represent or protect bad actors here. I think the testimony we heard today are really difficult and terrible, and we're not advocating for protecting bad actors. We don't necessarily have a problem with going from 5 to 3. I think it's just the idea that we need to, if there is a stop work order that we need to have, that to make sure that it's found, the person's found in violation of the work before and has an opportunity to appeal. If it takes a long time to get there, which we know it exists, I think that there's opportunity for us, if we could meet with you and others, to create some language that actually addresses that.
Okay. And then you raised, I appreciate that, and there will be opportunity to, I think you've worked with my staff in the past, so that opportunity is there.
Yep.
You also had some concerns on the insurance.
Yes, with the insurance bill, there's lots of questions with the type of insurance that is required. We know that this hearing is doesn't have any input from DISB, for example, who regulates insurance. So the types of insurance that if it's a new insurance that's going to be required, if it's builder's risk insurance, which is much more complex and technical and more expensive. We want the opportunity to sort of answer these questions as this bill goes through the process, so that we can input and make sure that the type of insurance is reasonable, and also the difference between a general liability and a risk insurance is very complex, and so the type of legislation is not really expressed in the legislation. So we wanted the opportunity to clarify and make sure that the right type of coverage makes sense for the existing problems that could potentially come up.
Well, I don't know what the difference is between general liability and risk insurance. Can you explain?
I know that the risk insurance is a lot more expensive. Risk insurance is for construction. General liability is also for construction. But I think the reason why we want to have more opportunity to work with you and the committee is to clarify the differences and to make sure that the right type of insurance is required for this to address the issue properly.
Well, do most builders have risk insurance?
Yes, both risk insurance. There's risk insurance and then there's general liability insurance, and there's all types of insurances through the entire process of construction. So I think insuring, since it's required of an adjacent property, and one of the things we want to make clear is that, if there's an adjacent property that doesn't have, that we'd like to be able to see what the existing condition is if you're going to require us to insure to protect that property next door. We don't know what the condition is, and it's fair for both parties to make sure that as we get insurance, that it's properly covered.
Well, I think that sounds reasonable, but that's a different point. If you're saying most construction projects have risk insurance as well as general liability, I don't know what the big deal is to extend that coverage to the abutting property.
I think that those are questions to get into. To be honest, I don't know the full details of the difference between them, but I know that our members know that, and we need to get it to have a further conversation to make sure that the right type of coverage. And it's also builder's risk insurance is for the construction project itself, and now we're requiring adjacent properties. So those questions need to be fleshed out to make sure that the coverage is proper and it's not cost prohibitive.
Okay, of course, that's what the public hearing is about, to try to flesh these things out now. But let me ask Mr. Glassick or Mr. O'Brien. Can you speak to this issue? And I'm a little hesitant about Mr. Glassick because his audio was pretty wobbly, but Mr. O'Brien, you've revealed yourself. Do you want to take the first crack?
Thank you, Mr. Chairman. There's always a risk in revealing oneself, but I'll take a risk at this. So first of all, the type of stories that have been shared by several of the witnesses at this hearing are troubling. And it is the type of thing that people buy insurance to handle. People buy insurance to take on a risk that is higher than themselves, or a risk that they had no idea that they were at risk for, shall we say. Obviously, there are some issues perhaps with some of the builders and contractors who are dealing with this, and you can't regulate away everything that is caused by a bad actor. And however, you can try to do the best you can by balancing the equities. There are a wide variety of insurance products available out there: builder, owner, and risk insurance, liability insurance. It can be somewhat expensive because there are a wide variety of risks presented during the course of a building, during the course of a construction, because construction is inherently dangerous and there is a risk associated with that. There are products out there in the marketplace now that do provide some level of coverage associated with the risks that have been articulated today by the various witnesses. There are limits, if you will, both in terms of the amount of available coverage as well as what would be covered. And at the end of the day, it's also a question of price. What is the appropriate price associated with the risk that's presented? And we, on the insurance side of things, we try to set prices associated with the risk as well. So these are all details, Mr. Chairman, that need to be fleshed out, and which is one of the reasons why during the course of my oral statement, I suggested that the folks at DISB need to be, and as indeed as they have been, integrally involved in this process. I hope that answers some of your question. I know that it probably precipitates others, however.
Well, what's the difference between risk insurance and general liability?
General liability insurance would cover things such as a slip and fall or things like that. The risk insurance would cover things that are associated with the construction of the property itself. That's at the 10,000 foot level. There are many other differences. I'm not an expert on the coverage issues associated with those products, but we would be happy to provide additional information to you and the council on that.
Well, please do that. But so, if I'm concerned that building a new structure next to an existing structure may cause damage to the existing structure, the appropriate insurance would be risk insurance.
It could very well be. It all depends on the design of the product available, and there are a wide variety of products out there that from a range of companies. So I'm going to give you the typical lawyer answer, Mr. Chairman. It depends.
Okay, but the idea of a contractor buying insurance to cover damage to the abutting property is not a strange idea.
No,
And do you have a sense of how expensive it is, like really expensive, or it's done all the time and it's just factored in?
again, Mr. Chairman, and I don't want to seem like I'm dodging the question, but it depends, because it depends on the size of the project. It depends on the conditions on the site. I don't want to mislead you, Mr. Chairman, or the council. It can be relatively inexpensive, but again, depending on the size of the project, the cost can be considerable.
Mr. Jones?
Mr. Chairman, if I may, thank you. Prior to testifying on this, what I was able to do was talk to several of our members here at AOBA who actually have projects that they've worked on. Also, prior to this, you may remember I served 13 years with the Associated Builders and Contractors, Metro Washington, which is the largest construction trade group, and I actually took some time calling some of the general contractors who I used to work with at my previous employer. And to a T, most of them stated that they believe that the risk insurance and other products that they currently carry would cover damage to adjacent or abutting properties. Their concern was that they would be required to get liability insurance that actually would not solve the problem trying to address. But most of them believed that the problem, in large part, was that many of the projects and the unfortunate examples that we've heard today from the witnesses, in large part, have been illegal construction. And those folks doing illegal construction are not going to get the general risk insurance required to cover them, even if we change the law and require liability. To the previous gentleman's point, most liability insurance is not going to cover the damage from a wall or underpinning or the actual excavating, et cetera. It's that risk insurance that those general contractors, subcontractors, and in many instances, those who are doing remodels and rehabs actually carry. It also, in many instances, is not the developer who's going to carry that insurance. It's going to be your general contractors, your first and second tier subcontractors who are actually going to do that work. And in many instances, based on the legislation, the requirement of trying to force a developer to have coverage or insurance that actually is covered by a general or subcontractor is actually opposite of the current general and best practices. Those subcontractors are going to do the excavating or that digging, or the folks who actually have insurance to cover the work that they're doing. There may be bonding or other forms of insurance at the next level up to cover the totality of the project, but those specialized folks who are coming in doing certain work are the ones who are going to actually have that insurance. Those plumbers who are going to go in and do that deep water work or that HVAC work under the property, where you're going to deal with gas lines and water lines, are the ones who are going to be insured for that type of work that they do. That's why if you look at it, most of those folks are required when they get licensed by DCRA to show that they have bonding, licensing, and insurance to cover those type of work, the type of work and damage that could be done.
Thank you. That's helpful. Let me just see if I have any other questions. Mr. Brandt.
Yes, thank you, Chairman. I agree with several of the comments that were just made. As you know, as a homeowner, your homeowner's insurance does not cover a neighboring large construction project. So if we could have purchased an insurance product to cover their work, we would have done so. And then they would have paid for our expenses and damage. And then they would have gone to the other insurance company to try and get that reimbursement. The problem is for them to actually use their own insurance company, they're going to have to initiate that. And if they don't want to initiate that claim, then we have to sue them to start that process. And so that's not a very efficient process. And so I'm glad to hear this initiative. I think these kind of products could be very helpful, but ultimately is the responsibility of the developer. I think what's unique about our experience is we're the only home immediately adjacent to a 2-block project. One home, only one home did they have to work with to protect. There's another home on 10th Street, which has had a 40 or 50 foot break between the property. But still, they didn't take the initiative to do so. So that's why these requirements are necessary, because people don't always do what's the right thing. Thank you.
Well, but Mr. Brandt, you make an interesting point. I'm assuming, based on the testimony from others, that the developers adjacent to you had insurance, because there was testimony that large
They have to have
contractors tend to
it.
have
Correct. They
insurance.
have to have it.
And your problem was that they weren't agreeing to work with you. And when you were pressing a claim, literally or generally speaking, they were not being responsive. And so, as you just said, the only way you could have forced the issue would have been to take them to court.
Right.
So they had the insurance, didn't do you any good.
Well, their having insurance hasn't done us any good thus far, correct? So that what they need is insurance on our home, so we could go directly to the process, initiate the process to avoid that delay and, for lack of a better term, cheapness. So thank you.
Interesting. And I see Mr. Hildum has his hand up. And in your case, if I remember correctly, it was illegal construction. And I don't know that any insurance product would protect against illegal activity. Mr. Hildum?
I think it was partly that. I mean, tearing down the wall, the interior wall, if he hadn't blown out the back wall, tearing down the interior wall would have been a problem. The only other thing I want to add, though, is I was told during this process when I was asking about whether he had insurance was, well, he's supposed to, but a lot of times they submit proof of insurance and then they let it lapse. And my suggestion, one of my suggestions, and I have submitted my testimony, Chairman, and I, again, thank you for this opportunity, but one of my suggestions would be, if my car insurance lapsed, the DMV knows about it. If you're going to require insurance, then make sure there's a notification to DCRA immediately that the insurance has lapsed, and there should be an immediate stop order in that case until they put the insurance back in place. But I was told that it's often common practice for them to submit proof to DCRA and then not pay the premiums.
Let me go back to Mr. Glassick is still here, but he hasn't revealed himself, for Mr. O'Brien. Mr. Glassick, can you speak to this for Mr. O'Brien?
Mr. Chairman, I purposely.
Turn off his camera.
I'm sorry.
If Mr. Hildum can repeat the question, just make sure I got it correctly. And I do apologize.
It may be the thing to do is for you to go back to having your video off. That might help. How do you require insurance to cover illegal activity?
You cannot insure for illegal activity. That's one of the basic principles of insurance. And you also can't buy insurance for a property which, or for something in which you do not have an insurable interest. So the concept of having a contractor buy insurance for the adjoining property does not make sense in the legal that insurance can help with.
Okay, well then help me with this. Just to use Mr. Brandt as an example. So he's adjacent to this construction project. The construction project was two large developers who presumably have insurance. He had some damage to his property. He can't go to the construction companies or developers, insurance companies. He has to go to the developers, and the developers deny everything. Now what does he do to get how do I say, compensated, other than going to court?
Other than going to court, I mean, until liability has been assigned, then the insurance product wouldn't respond. So liability would be assigned
Oh,
by,
you're welcome.
by a court.
Mr. Brandt, you look like you want to say something here.
Thank you. I do, obviously, you can buy life insurance on any person. So there are insurance products that you can buy on other, whether you have a quote insurable interest or not. I think I heard earlier that there are products that exist that would address this issue, or they're in development. So I don't think that's an insurmountable issue from my perspective.
Mr. O'Brien, you look like you were agreeing there.
Yes, Mr. Chairman, as I stated during the main portion of my testimony, there are companies that now have developed products and are offering them in the marketplace that would respond in this situation. And we do anticipate that there will be other companies that will also be in place to offer a product that would deal with this risk.
Okay, give me just a moment. Mr. Hildum?
Thank you, Mr. Chairman. I'm troubled. I mean, yes, there was illegal construction, but I think then maybe the council has to consider what's the protection for illegal construction. Because if this bill doesn't cover that, then what protections do we have? Because one of the other things I found out was that he had a playbook that my consultant and my architect had seen, including his schematic drawings. And they said, no, this is the basic playbook. He gets a basic permit and then he does whatever he wants. And so if that's a basic playbook, and if people are saying, well, there's no insurance for illegal construction, then there needs to be protection for adjoining homeowners who suffer through illegal construction or even incompetent construction. But I think it's pretty clear his intent was to do whatever he wanted to do. It didn't matter what the permit said. And I think that needs to be protected.
I agree, and that's what we're struggling with.
Thank you, sir.
Mr. Glassick?
And I apologize if I missed this because of the bad connection. I am stuck in a hotel ballroom, but is it appropriate? Well, I addressed my question through the chair, but did Mr. Hildum share whether or not he had made a claim to his homeowner's insurer? I don't know that I heard that or not in it.
Yeah, I don't know either. Mr.
I
Hildum?
did. I did, but the answer isn't for me to suffer an insurance claim that they're going to raise my rates on. I did, and they are attempting to locate his insurance company. By the way, he had moved from his corporate address by the time we had done this. Oh, and let me back up a little bit, okay? We fixed the wall out of pocket because we had to gain access to his side of the house to properly fix the wall. I couldn't do an insurance claim immediately because I'm pretty sure he wasn't going to let me near the property if I did an insurance claim and my insurance company reached out to him. So we fixed it. And then after we fixed it, we submitted the claim. And then they have been trying to track down his insurance company. My understanding is that finally, after several months, they did find one and they're talking to them now. But as a practical matter, it's $15,000. And if they say we're not paying, my insurance company's not going to sue because it's too expensive. And so then the burden is again on the homeowner. And I just think that's patently unfair. And what he has gotten away with, what he's attempted to get away with, and pretty clearly what he's doing is the playbook. So as much as people want to talk about bad apples and, oh, we don't like bad apples, guess what? They're everywhere and you do have to deal with them. And I'm sorry, but that's a fact that this practice is too prevalent to be ignored and to be brushed off as bad actors. He had a playbook and he was playing it.
Thank you. I'm not going to keep recognizing hands. We'll do Eric Jones, and then I think we'll be done. Mr. Jones? Mr. Jones, you may have frozen.
I'm sorry, I didn't get off mute. I know there's been a dialogue back and forth about how we deal with this. And unfortunately, if we pass new deal with illegal construction, the process of going after someone via insurance for illegal construction is not going to change because it is still illegal construction. So the process of filing a claim with your insurance and having them seek someone to go after them is not going to be changed. The problem is that there's illegal construction that's not being addressed.
Right, I think you froze.
So, can you hear me?
Not very well.
that better?
Something makes me think you moved from where you were when you gave your initial statement.
I haven't moved at all. We're having some work in our neighborhood by Comcast, so our signal's up and down today, unfortunately. I'll send my additional comments via written statements. Thank you.
That would be great. All right, I want to thank each of you. This testimony has been helpful. A couple of you were going to submit your statements. We actually got yours, Mr. Hildem. So thank you for that. And if anybody wants to supplement their remarks given this conversation, that would be helpful to us as well. Again, the record will be open for 2 weeks. Thank you again. You all are excused, and I'm going to call Ernest Trompa. Ernest Trompa, who is today the Director of the Department of Consumer and Regulatory Affairs. Give me a minute before you start. Give me another second. Mr. Trapper, when you're ready.
Thank you, Chairman. Good morning, or actually good
Morning.
afternoon. Chairman Mendelson, council members and staff. I am Ernest Trapper, the Director of the Department of Consumer and Regulatory Affairs, DCRA. I'm here today to testify on Bill 24-201, the Construction Management Agreement Amendment Act of 2021. As you're aware, this legislation would require a permit applicant to enter into a standard construction management agreement with a chief building official or a voluntary CMA with neighboring property owners, depending on the size of the properties. This bill also reduces the number of stop work orders from 5 to 3 within a 1-year period that could trigger a denial of future permits for a 1-year period. At the outset, I want to commend the council for drafting a bill that seeks to strengthen the construction codes by addressing noise disruptions, after hours work, and other nuisances caused by abandoned large-scale construction, commercial construction projects. The overriding goal of providing relief to district homeowners from construction that impacts their property is something that the mayor and I feel strongly about, as evidenced by the legislation introduced by the mayor, which is the subject of the hearing today, Bill 24-924, the Protecting Adjacent and Adjoining Property Owners from Construction Damage Amendment Act of 2022. I understand the council's concerns, and while I do believe that DCRA has improved its enforcement procedures and processes over time to ensure that district residents are able to enjoy safe and habitable living conditions, there's always more that can be done. With that said, DCRA has several suggestions that I would like to share with the aim of making this legislation more effective and workable. First, DCRA has a broader concern about the use of the phrase construction management agreement, which is a well-known term in the construction and development industry. CMAs are commonly used when developers and construction companies complete public and private projects. In fact, one widely used definition states that a CMA is a contract between a contracted construction manager, CM, and a project owner. These agreements establish the specific roles, responsibilities, and obligations for both parties for the contract period. By using this specific terminology, the bill implies that a chief building official works for the owner and is being given responsibilities of a construction manager. DCRA has concerns about the implications of such language and recommends that these agreements be called something else, such as impacted neighbor agreements. Next, there is a requirement in the standard CMA that states that the permit applicant is required to provide vibration monitoring services for a property abandoning the project if a third-party engineering report demonstrates, pursuant to rules adopted by the mayor, that the project is likely to cause vibrations that would exceed an amount determined in rules adopted by the mayor. While we appreciate the intent to ensure that vibrations from construction work do not contribute to any damage to abandoned properties, vibration monitoring is not necessarily needed for every project. Moreover, there is no precise or industry agreed upon level at which damage begins to occur. For this type of monitoring should be conducted on a case-by-case approach and should not be mandated for all projects. While it may be a factor for projects where pile driving occurs in proximity to a fragile building, for many construction projects, there are no hard and fast metrics that establish what intensity or frequency of vibration is a risk. The bill would also require the mayor to adopt rules to determine excessive vibration levels. DCRA is in no position to determine such levels, and even if such levels could be established, it is unclear what the agency will do with that information. Although we do not think that routine vibration monitoring is necessary for the reasons stated above, it may make sense to codify the building official's authority to mandate vibration authority when needed. Regarding language that relates to noise, disruption, and after-hours construction, This seems duplicative of what is already on the books and is currently being enforced by inspectors. As of now, the maximum sound level, which is established in Title 20 of DCMR, is 80 decibels. And if it is exceeded, the permit applicant needs to apply for and receive a temporary exemption. In order to get this type of exemption, the appropriate Advisory Neighborhood Commission, ANC, review is required before DCRA will grant the exemption. In this sense, a process is already in place to notify impacted property owners through their ANC. Similarly, the same type of ANC review is required for after-hours permits. While it is accurate that the agency does not individually notify impacted property owners, one would assume that an ANC would contact these parties before weighing in. But if notifying impacted properties directly is something that the council would like to codify, DCRA does not see any reason to object. We would recommend that property owners provide or update their email addresses on file with DCRA to receive automatic notifications at a minimum. The bill further proposes a novel concept that requires a permit holder to reimburse an impacted property owner for a night in a hotel at a rate allowed pursuant to rules adopted by the mayor. When the permit holder performs work outside the hours allowed pursuant to 12A DCMR 10.5.1.2. It is unclear from the bill who will be responsible for regulating the reimbursement. It would not be appropriate for an agency to be in the business of monitoring, recording, and validating payments for bills related to hotel accommodations, or to insert an agency into the middle of a dispute between two private parties. Furthermore, it is unclear what would happen if an impacted property owner is not reimbursed. Would they have a private right of action? Could a lien be placed on the property? This ambiguity in the bill is problematic, and that warrants removal of this provision from the bill. Additionally, the bill would require that for a standard CMA, the covered applicants provide proof of liability insurance in an amount determined pursuant to rules adopted by the mayor for the project for which the covered applicant is seeking a permit. While this language does create a new requirement by mandating insurance coverage, requiring proof of insurance does not offer any meaningful protection. And let me explain why. As you're aware, DCIA requires a general contractor or construction manager to obtain and provide proof of commercial general liability insurance before issuance of a license. Unfortunately, we've learned that there are no such provisions in CGL insurance policies, which all licensed contractors must possess, that cover and protect abutting, adjacent, and or adjoining properties from damage that stems from a construction project. This is why the mayor has introduced Bill 24-924, the Protecting Adjacent and Adjoining Properties from Construction Damage Amendment Act of 2022, which would close the gap in coverage by requiring additional insurance on top of the CGL insurance to cover adjacent and adjoining property owners if any damages occur during a construction project. We strongly encourage the council to pass Bill 24-924 as it is necessary to cover the gap that exists in Bill 24-201 relating to proof of insurance. Next, it is unclear what problem this bill is trying to solve by mandating a CMA, where at the end of the day, the parties have to go to mediation. In mediation, of course, nothing is binding. A disadvantage of mediation in the context of property damage or quality of life issues stemming from construction is the lack of enforceability of the CMA and the risk that mediation could potentially become a strategy for one party involved in the dispute to drag out the issues. While there may be a cost associated with arbitration, our suggestion is to replace mediation with binding arbitration, which has more teeth. Finally, I must flag that this bill will have a fiscal impact on the agency, and these are costs that cannot be absorbed. For example, there will be a cost associated with monitoring and tracking standard CMAs, which are between the permit applicant and the chief building official. These new responsibilities will have personal services and non-personal services costs associated with it. In conclusion, I'd like to thank the council for putting forth a bill that ultimately seeks to protect homeowners from destructive and harmful construction. As I expressed earlier in my testimony, the mayor and I share these concerns, and I can assure you that DCRA and its successor agencies, the Department of Buildings, will continue to work tirelessly to promote what is in the best interest of property owners in the district. Chairman Mendelson and members of the council, thank you for the opportunity to testify and provide feedback on this bill. With that, I'm happy to answer any questions you may have. Or Chairman, if you'd like, I can continue to the testimony on the other bill.
I would like you to, but you could forego the opening paragraph that you already read on the last bill and the closing paragraph that you already read on the last bill. But yes, please proceed to your testimony on 924.
Thank you, Chairman. I must say that I'm really excited to discuss this legislation as it tackles a well-known problem in the district, which is damage to adjoining adjacent properties by neighboring construction work, and provides a concrete and action-oriented solution, which is to require those seeking a permit to obtain liability insurance for the project. In the District of Columbia, there is at times a misconception that any damage to adjacent and adjoining properties that occurs during construction work by a neighboring property owner or their contractor is automatically covered under homeowner or general contractor liability insurance. This is to some extent understandable because insurance contracts can be long, confusing, and in some cases, not completely transparent. It is also not reasonable to assume that homeowners can be experts on every detail of their or their contractor's insurance coverage, particularly when the requirements may be ambiguous. DCRA has received extensive feedback from the community on how, in certain cases, existing coverage under general contractor liability insurance or homeowners insurance is inadequate to make neighboring homeowners whole, given the scope of damage which occurred and in some situations under unique circumstances. Part of the problem is that when damages occur during construction, this can lead to multiple lawsuits between insurance companies and other parties, including homeowners, contractors, subcontractors, but no immediate relief is available for the adjacent or adjoining property owner. Generally speaking, there is nothing specifically dedicated in the general contractor liability insurance for adjacent and adjoining property owners. And there are hard limits on general contractors liability insurance. In short, district homeowners and their contractors are simply not always aware of where the coverage ends. DCRA is cognizant of and sympathetic to these concerns, and we have been diligently researching potential solutions since early this year. Indeed, we even brought in outside consultants to socialize the issue with insurance providers and looked at novel remedies offered by other major cities to get to the root of the problem. What we ultimately determined is that New York City has a viable regulatory structure that we can use as a model for the district, with certain changes given the particular needs of our city. To provide some context, New York City's model establishes coverage amounts based on the number of stories of the neighboring property. While this is not a proposal that will work in the district since we do not have any skyscrapers, we plan to follow New York's lead in issuing through regulations after the legislation is enacted, which clarify the specific coverage requirements for different property owners. Turning now to the mayor's legislation, this bill seeks to protect adjacent and adjoining property owners if their neighbor damages their home during a construction project. This legislation would require property owners, contractors, or persons applying for a permit for construction work to obtain liability insurance to insure adjacent and adjoining property owners for loss or damage arising out of the proposed work for any projects that require neighbor notification or will have a detrimental impact to immediate neighbors. Notably, the bill puts the onus on the property owner, contractor, or person applying for the permit to maintain this insurance coverage, not the adjacent or adjoining property owner. This legislation establishes a straightforward insurance requirement to protect district homeowners. We are now proposing an extensive regime, which will add significant budgetary burdens or implementation challenges for DCRA or its successor agency, the Department of Buildings. Our concept is to create a universal requirement that will largely be handled between district property owners and insurance providers with appropriate government oversight. Next, I'd like to turn to the proposed scope of coverage. The trigger for the insurance requirement is if the permitted work would require neighbor notification under the construction codes or based on the risks associated with the proposed work. Neighbor notification, as you know, is required when a permit for a construction work may be issued that can impact or damage adjoining properties. Under current law, neighbor notification forms must be distributed by the property owners undertaking a project to adjoining property owners prior to approval and issuance of building permits, and must include either a copy of the proposed construction documents or instructions to view and download these documents online. The homeowner undertaking the construction project must notify the adjoining homeowner and provide a copy of the notification to the code official not less than 30 days prior to permit issuance. So it would be in these circumstances that insurance requirements will kick in, or when the chief building official determines the risk associated with the proposed work requires such insurance. I would also want to highlight that this legislation is not intended to make this new insurance requirement unaffordable or overly burdensome for property owners, contractors, or their agents. Indeed, the thought going into this was to make it something akin to the prototypical fee to add insurance coverage to airport car rentals, which can sometimes be as low as $9, with the understanding that the amount will be higher given the type of car that you drive. Similarly, the cost of insurance coverage here will potentially be as low as $55 to $100 range, depending on the cost of the proposed construction work and other factors. Moreover, a relatively minor investment by the party applying for a permit could allow for up to $1 million or more in coverage, and this coverage can be added to the contractor's commercial general liability insurance. As I stated, this legislation puts the onus on the property owner who is performing construction to secure the insurance. Since the District of Columbia is not a direct action jurisdiction, this means that the neighbor or the homeowner performing the construction work cannot make a direct claim on the property owner doing construction work. Instead, the adjacent or adjoining neighbor can file a claim with their own homeowner's insurance, who will then contact the property owner doing the construction work and their insurance carriers to file a claim and seek reimbursement. DCRA, as part of this program, will encourage residents to notify us of claims against contractors and neighbors as part of the complaint process. As part of socializing this legislative proposal and to provide comprehensive information to district homeowners, DCRA has established an insurance education center located at dcra.dc.gov/insurance center. After October 1, when the Department of Buildings is operational, the website will be dob.gov/insurance center. The scope of information on this website goes far beyond the proposed new requirements on adjacent and adjoining properties. The Insurance Education Center provides guidance on current insurance requirements for certain types of licenses and general information on important considerations for homeowners and contractors regarding the issue or issuance of insurance. Our goal was to create a comprehensive insurance information resource for district residents. DCRA and our successor agency, the Department of Buildings, will continue to update the Insurance Education Center in the coming months to provide the most up-to-date information to homeowners and contractors. Our Insurance Education Center will continue to be a valuable portal after adjacent and adjoining property insurance requirements are put into place. My team worked expeditiously to stand up this new resource, and we are very pleased to offer it to inform district residents. I want to be clear, however, that DCRA's Insurance Education Center does not endorse any particular insurance provider or product. Our intent is only to provide general public information, including answers to frequently asked questions about coverage options. For example, the site clarifies routine concerns about how disputes arise between contractors and subcontractors and the impact this can have on residents, among other homeowner concerns. Next, it is important to note that the mayor's legislative proposal has not been ensconced in a bubble within the agency. DCRA has been working extensively with the DC Department of Insurance, Securities and Banking, as well as local and national insurance providers over the past several months. DCRA's successor agency, the Department of Buildings, will continue these collaborations. DCRA made a presentation to the Property and Casualty Subcommittee of the Insurance Advisory Committee at DISB and held a question and answer session on July 27, 2022. DCRA also held a webinar with members of the public on August 9, 2022. I am happy to report that insurance publications and the national insurance industry have taken notice. For example, there has been broad industry outreach to the U.S. Council of Insurance Agents and Brokers regarding the mayor's proposal, and other cities are contemplating similar models to New York City's legislative requirements and what we have proposed. I also want to note that our intention from the beginning has never been to create a legislative mandate that the industry will not be able to meet. To the contrary, this has been a very productive and informative process, which my team and I are pleased to be part of. We look forward to continuing this dialogue in conjunction with the passage of this legislation. The Department of Buildings, which will become operational tomorrow, will also be tightly focused on implementing their proposal and providing regular updates to the public. Understandably, many questions will be raised about how the insurance industry can and will respond to this mandate. I'm pleased to report that due to DCRA's outreach, we already have at least one provider who is available to issue coverage in the mold of what we would require once this legislation is enacted. And as I've shared in the testimony earlier, there are several providers who are also ready to offer this product. So that is particularly encouraging. So our proposal is not just a concept on paper. It is already available as an insurance package for district residents who wish to attain coverage before it becomes a requirement under the legislation. We are fully aware that for providers to establish new forms of insurance, it generally demands a countrywide demand. And while we have engaged with local providers, we understand that national coverage will eventually be needed. This is why we've been working closely with the insurance industry and are confident that after the District of Columbia and other major cities adopt requirements for adjacent and adjoining property coverage, there should be a number of viable policies available to residents. I also want to point out that DCRA views the insurance industry as a partner with regard to the problem we are addressing through this legislation. Specifically, we believe that they can provide valuable assistance in highlighting bad actors who are operating in our city and penalize them for the harm posed by negligent contractors. The insurance industry can also work in tandem with the district government to set rates which are affordable for our residents. We look forward to continue to engage with the insurance industry as our proposal moves forward to passage and implementation. Chairman Mendelson and members of the council, thank you for the opportunity to testify. With that, I'm happy to take any questions you may have.
Thank you, Mr. Trump. And yes, I was here, even though I had my video off. I'm not quite sure where I want to start with questions. Outside of New York City, what other jurisdictions, if any, have a similar requirement for the insurance?
In our research, we discovered that New York City is the one that has implemented fully such a requirement. Other cities are considering it, but it's not resulted in actually a regulation yet.
Do you know if any cities are on the cusp?
San Francisco is one example. Philadelphia is another example. I have to check with my team, but those are the ones that come to mind.
Can you say what insurance companies, if any, currently offer insurance like this?
Currently, for the District of Columbia, I know Shield Indemnity Inc. offers this product. I also know, based on testimony shared today, that several insurance providers can have this coverage as well. So eventually, we would love to have all of them listed on our website so that people have an easy resource to go to understand coverage options, who is offering it, and to do price comparison shopping.
Your testimony suggests the cost of this insurance could be between $55 and $100. How did you arrive at that rough estimate?
It is based off a product that is currently available by Shield Indemnity. So, for example, if on top of the commercial general liability insurance, if a project owner has a scope of work that is around $50,000, they can get coverage, 100,000 single occurrence, 250,000 aggregate for as low as $55, which is less than $5 a month.
You sounded like a salesman there for a second.
As part of the research, I wanted to make sure that I give you the accurate information and also to inform the public, because we know that commercial general liability policies don't cover this, so people think it covers it. And we spent a lot of time, had conversations with these insurance providers to ensure that there is a product available to solve this problem. So that is why I'm a bit more passionate about it.
In New York, certain projects are exempt, even if they require a permit. What thought have you given to potential exemptions?
Yes, if somebody wants to put up a fence, a work of that nature should not require the unique protection and coverage that we're talking about. If somebody wants to renovate their basement and replace the sink, change the bathtub, small scope of works or work that does not pose significant risk to adjoining adjacent properties will not require this type of insurance.
Well, that's because you identified projects that don't require notification to neighbors.
Not just projects that don't require notification to the neighbor, projects that would pose significant risk based of signs will be required to have this insurance. So, for example, if there's going to be pile driving and the adjacent property is an old building or a fragile building, science tells us there will be significant impacts and there's a need to protect the property owner and residents.
So that's looking at how the applicability of the bill you're proposing, how the applicability would be broader than just simply instances where an abutting neighbor needs to be notified.
That's correct.
But my question was different. In New York, some projects are exempt from this requirement. Did you give any thought about exemptions where there would be neighbor notification required?
Oh, so if I understand you correctly, your question was, have we given any thought to exempting projects even when neighbor notification is required?
Correct.
Yes, that is something that we can flesh out through the regulatory process to narrow the scope. And that is one of the ways that I think the APA becomes a benefit, in that we would issue proposed regulations, go through an extensive public comment period, make changes as necessary before going to final rulemaking. So yes, we've put some thought into that, and we would welcome feedback from the industry and our partners that we've been working with so far on this to make that vision a reality.
So your intent behind the bill. I'm trying to see if I can put my finger on a copy of the bill.
I can share screen if it's helpful.
Nope, that's okay, I've got it. Okay, so your intent is that through rulemaking, you could say more about permit work that does not require neighbor notification. And you also could say more about construction work that does require neighbor notification.
That's correct. And through the rulemaking also, would also establish critical factors as what the value will be based on. We've contemplated using the assessed tax value as a practice so that there's no ambiguity or arguments around the value of a neighboring property. So those are things that will be hashed out through the rulemaking process to fine tune the operational elements for implementing this proposal should the council pass this law.
Let me just say that the bill's introduced, I don't read that flexibility, but this is helpful. So your intent is that you would have that flexibility through rulemaking. I think
Yes.
you were going to say yes.
Yes, sir.
But what about the instances that the witnesses were talking about? So let me see if I can kind of go through this. Let's take the property on Mr. Brandt, who lives south of H Street, if I remember correctly, has to live south of H Street because it's adjacent to the property that was used to be the 10th Street connection and has now been redeveloped. So he felt that he was damaged. I'll just assume that the allegations are correct, even though I recognize that they are allegations. But for purposes of asking questions, we'll just assume they're correct. So the developer was a mixed-use commercial residential property, fairly large. The developer damages the abutting residents' house. Not huge damage like a collapse, foundation cracks and all that, not huge like that, but damages the property. So Mr. Hildem goes to the developer and says, hey, you damaged my property. The developer doesn't cooperate, doesn't admit there was damage. So how does, under your bill, how does Mr. Hildem get access to the insurance coverage that the developer has?
First, the insurance product we are talking about here, the adjoint property protection coverage, establishes coverage. So there's no ambiguity as to whether this is going to be a covered item or not. There is coverage for it. The homeowner would notify the developer, as you mentioned, about the damage. The homeowner would also notify the homeowner's insurance company so that the homeowner's insurance company has something they can go after based off the product that has been established. The homeowner will also notify DCRA or its successor agency, Department of Buildings, about a claim. And it will be resolved through the claim process between two insurance companies. What is different here with the passage of this bill into law is that there is a clear product and coverage to protect the homeowner so they don't have to deal with competing claims, fighting insurance companies, and risking their own insurance rates going up.
So I'm not sure the legislative language is clear on this point, but your intent is that the property owner, in the example of Mr. Hildum, he contacts the developer, he feels the developer is not responsive, he could go to the insurance company.
Yes.
I'm just making a note. Now, there was testimony that that's not usually the way insurance works. So I remember years ago, somebody pulled out in front of me and I hit them, and I had to deal with my insurance company, and I tried to deal with the person who pulled out in front of me, but I wasn't able to deal with their insurance company. I had to go through either the driver or through my insurance company. But your intent is that I realize I'm mixing buildings and automobiles, but your intent is that I could go to the driver's insurance company directly.
No, when I say insurance company, I mean, you would contact your own insurance company, but your own insurance company would follow up with the developer's insurance that provided that coverage, the property owner's coverage. So let me use homeowner to mean the person who's impacted, property owner or developer to mean the person doing the construction. So that is a little bit clearer. The homeowner contacts their insurance company. The homeowner's insurance company follows up with the property owner or developer's insurance company that issued the unique policy that we are talking about to get the claim processed for the homeowner. So it works the way insurance works today. The difference is that there's a dedicated product that the homeowner's insurance company will be making a claim against. Okay,
That answers that question. So what about the situation with, I misspoke names. I should have said Mr. Brandt and I said Mr. Hildum. Mr. Hildum was the one on 15th Street where, if I remember correctly, he characterized I'm going to say small-time developer who was building or rather reconstructing the house next door, that developer blew out the back and then basically destroyed the party wall with Mr. Hildum's house. So that exceeded the permit. I would characterize it as illegal construction. Insurance doesn't pay for illegal construction. I think I have two questions. One, what you're confident that you would require of that developer insurance before he, as provided in your bill. You're confident that that you would require insurance of the developer before he began work, correct?
absolutely. And it will be automated. They wouldn't have a choice.
Okay.
Clear. It's not like there's going to be a human involved here. And that's part of the reasons we invested in the Insurance Education Center. You would have to provide proof of the policy before the permit is issued. And what is unique about this proposal also is that if there is a cancellation or a lapse, it would require 30-day advance notice before you can terminate that policy. And it also establishes a dedicated limit for the project, because we know even though people can have commercial general liabilities, there are other claims that can eat it up or basically drain that are aggregate or single occurrence like no limits. But this is specifically for the project that is being undertaken and specifically to protect the adjoining and adjacent property.
Okay, so, but insurance does not cover illegal activity. And so if the permit says you can build a bathroom, I'll even go a little further. You can build a bathroom and you can renovate the bedroom. And what the guy does is renovate the kitchen. And what the guy does is blow out the back wall and destroy the party wall. That exceeds the scope of the permit. Insurance it does not cover illegal activity. So now what happens?
Yes, generally, insurance doesn't cover illegal activity from the damages that we've seen come through our agency systems and talking to homeowners and also developers. Damage doesn't just occur by a single event. It is usually progressive. So in the example you gave, the construction that was ongoing started the damage before the developer exceeded the scope of the permit. So I think based on everything I know so far and what I've heard about these testimonies, some part of the damage will be covered generally because the construction work caused the damage. Yes, there was exceeding the scope of the permit, but that came secondary.
You lost me on that very last point.
I'm breaking it into two phases. There was ongoing construction work that was causing damage, and then there was exceeding the scope of the permit that caused further damage. The insurance coverage, specifically to protect the adjoining adjacent property, would have been an option for the homeowner before things got worse. But no insurance product I'm aware of will cover illegal activity.
So let's take Mommy Preston's house, because you're familiar with that. If this bill had been law, how would she have been protected?
And I've actually spoken to Mamie about this, and her situation weighed heavily on me as we were thinking through various scenarios. If this was law at that time, the progression of her damage would not have happened because she would have been able to have an appropriate recourse or coverage for damage to her foundation walls, the windows that could not open anymore. It's actually a poster child example of the need for this type of insurance product, because in Mamie's situation also, the developer actually had a policy, they had general liability policy, but it excluded any damage to an adjoining and adjacent property. And that is why it's really important to pass this law, because people will say, yes, there's coverage under the existing CGL. No, there isn't, because if there is, show me a certificate of insurance that expressly does not prohibit coverage for adjoining and adjacent properties. And two, does not have some funny language that protection is limited to the site that you are working on. Mamie would not have gone through all of the pain and the financial cost that she'd had to endure if this was law at that time.
Let me turn to the other bill. So the other bill gives developers a choice. A developer could be small or large. I think it's 4 units or more residential, or 1,000 square feet or more commercial. 2 choices: a standard construction management agreement, and I take it, I mean, I recall you said you don't like that term, or a volunteer agreement. And those agreements would be between the developer and the building official, which is you or your designee. You didn't seem to have a problem with Well, you had a problem with the name and you had a problem with some of the details, but you didn't seem to have a problem with the concept of an agreement between the developer and you. Correct?
Not really, but we're providing suggestions because of the downstream impacts. This idea of having some type of agreement, we don't have a problem with it, but we think in its current form, it could be made much more effective by adding teeth to it. For example, mediation. No, why go to mediation when it's voluntary? People will just drag out the issues. Make arbitration like required, and people have to abide by the consequences. So it has enforcement teeth. As far as other ways to make it like stronger, yes. Don't call it like construction management agreement, because that sends the wrong signal. I see that code official or building official is working for the owner. We don't. We are a neutral person regulating our construction. So it is more to address any misconceptions about it. That was the underlying reason we are suggesting call it something else.
So did you consider whether this approach exposes the government to potential liability?
As far as the agreement is concerned,
Yes.
I think our lawyers or even the Department of Risk Management will be better suited to address that. But conceptually, I didn't see that. I'm not a lawyer, but I didn't see that as exposing us to some liability.
The bill, as I mentioned, involves a project that requires a permit for at least 4 residential units or 1,000 square feet of commercial development, and that abuts at least 1 residential property. Roughly how many permits are we talking about in a year?
Well, that scope of the top, I cannot say. What I do know is we issue about 54,000 permits a year, and it's split between residential and like commercial projects. And of that amount, at least 25% are postcard permits or small scopes of work, like electrical work, plumbing work. But as to how many permits will be impacted by this, we'll have to run the numbers, Chairman.
Is that how difficult a task is that?
Ooh. I would like to get back to you on it because, in the middle of transitioning systems, pulling data, and yes, I'd love to get back to you on that with something.
Okay. Well, I'm not looking for a hard and fast, specific, absolute, completely accurate number. I'm looking for approximate.
Okay.
So how many projects are we talking about when we say a permit that involves at least 4 residential units or a commercial development of 1,000 square feet? I have to say, I think 1,000 square feet is pretty small.
It is. It's not. It's a small scope of work. I agree. Maybe 20% of our 54,000 permits. I'll do the math here.
Yeah, let me just see something.
$10,800. So about 10,000 projects.
Give me just a second. Yeah, I'm looking quickly at 24-201. And it doesn't seem to restrict what permits are applicable to this or affected by this bill, other than 4 units or more residential or 1,000 square feet or more. I may be reading that incorrectly, and we could tighten that up, because obviously an electrical permit for a 8-unit apartment building is not something that needs to go through all this. But I would like to get a sense of how many units we're talking about. When I say units, I mean permits we're talking about. So the bill 224, so you'll get back to me on that? So the bill contains a provision that would change from 5 to 3 the number of stop work orders in a 12-month period that could be denied permits. Right now the law is 5. How often has the current law been invoked? You're muted. If you're talking, you're muted.
Thank you, Chairman. Sorry about that. We've used it a few times, at least in our recent memory, because I recall a project we did to look at not just developers and contractors, but also expediters who are associated with projects, and the number of times that they've received more than 5 stop work orders in a year. And we give them notice that this could lead to denial of permits, and we give them an opportunity to also provide additional information so that their name can be cleared. So for example, if I'm not a project owner and I'm associated with it, ultimately it's the project owner and permit holder who's responsible. So we've done some work there to fine-tune that process and also understand its limitations. Changing it from 5 to 3, we are not opposed to it, but we think it should be a discretionary enforcement strategy, just based off how the industry works, and also what we know will be situations where there are multiple owners on a property. One is just a silent partner, another is actively leading the construction project, another is providing financing, and the stop work order impacts all of them. So there's a fair amount of research that needs to be done before conclusively saying that you are solely responsible for all these stop work orders. So by going from 5 to 3, yes, it raises the bar, but it also increases the need to be better at research.
So you're saying that there is a problem with who is stopped from permits
That's correct.
if there are multiple stop work orders on a project that has multiple partners.
Yes.
But in terms of the current law, the number of projects or sites that have been denied permits a few times was your answer.
Yes.
I could ask that a little differently. How often has DCRE issued 3 or more stop work orders for the same project in a single year?
I have to go back to that analysis we did earlier on to see how many times or the incidence of a project incurring more than 3 stop work orders.
I mean, it seems to me that the instances where you have to issue multiple stop work orders are instances where you're dealing with a bad actor.
Yeah, and the violations sometimes range from something as simple as failing to take a protective measure, which you can correct the same day, whether it means putting a barrier or a fence, to scenarios where somebody is doing work without a permit, or scenarios where there's just reckless endangerment, or scenarios where we are questioning the engineer's calculation based off observed conditions versus what is in the plans. So stop work order can be issued for different scenarios. It couldn't be issued for working on a holiday when you're not supposed to work. So not all stop work orders reflect the egregiousness of the issue. So when you take just a number, 3, and say for every 3 automatically denied permit, it is problematic to administer it effectively. We want the discretion to remain with the building official or the code official, or in the context of the Department of Buildings, the strategic enforcement administrator, to also weigh in on how all of this should be implemented so that it is equitable, it is fair, but it has the desired impact in stopping bad actors from coming through the system over and over again.
Correct. I'm just thinking that I could get where not having a safety fence would be grounds for issuing a stop work order, because if a safety fence is ensuring safety of the workers, then you want to stop the work until the safety fence is erected. And generally where we're concerned about bad actors is where we're talking about illegal construction. But you mentioned working on a holiday. I think there's a high correlation between illegal after-hours work and illegal construction. Would you agree?
There is a correlation. I agree, there is. The degree or the strength of that coefficient varies. Because I've come across genuine scenarios. I don't want to say genuine, like scenarios where the subs, this is their first time actually working in the city, and they just can't get their head around the idea that, yes, right here in Tacoma Park on the Maryland side, there are certain days you can do construction. But in DC, no, you cannot do that. And if you ask a sub, you have to talk to the general contractor and the owner, and you realize, okay, there's a communication gap there, or general lack of awareness as you go down the value chain as far as our construction laws are concerned. So I share that as an example where people make mistakes, and we just issue a stop work order and send them home. But then there are those who would rather work at night, unsafe conditions, under cover of darkness, or on holidays to try to build a 2-story addition over a long period of time. Those are like the really bad actors that we should prioritize our efforts on.
Yeah. Give me a second here. So in your written statement, where you talked about vibration monitoring, you said this type of monitoring should be conducted on a case-by-case approach and should not be mandated for all projects. While it may be a factor for projects where pile driving occurs in proximity to a fragile building, for many construction projects, there are no hard and fast metrics that establish what intensity or frequency of vibration is a risk. But, okay, so when I listen to that, okay, but I'm not sure that the law would be implemented, or the requirement for vibration monitoring would be implemented required with any fidelity if we don't define in the law when. So you're saying this is subjective, should be considered on a case-by-case basis, but I think that is an open door to it not being implemented at all.
That's not the intent, and that is not the vision we have or our suggestion. What we are trying to illustrate is that it is not an exact science. So requiring vibration monitoring across the board in that nature is a blunt instrument. And it doesn't really allow the agency to target the requirement to appropriate scenarios. If you look at the relationship between, and there are studies on this. One is by this guy called Dr. Ziegler. He looked at the percentage of damaged homes versus vibration intensity. And it looked like an S curve that is leaning slightly 45 degrees. What that tells you is that there is some safety or safe zones when it comes to vibration monitoring, but its impact on damaging a property depends on other factors, type of construction, whether the building is not fragile, but people easily run to vibration monitoring as a solution when in reality, that's not really the solution to preventing damage.
I'm not sure I'm following, but before you try again, the impetus for this bill, Bill 24-201, was probably several instances of illegal construction, but there was a circumstance that I'm quite familiar with because it was a neighbor of mine, the 1200 block of E Street. There was a large apartment building that was erected on Pennsylvania Avenue, separated, I want to say by an alley, but I'm not sure it is an alley, separated by a setback that's, well, because the block is triangular in shape, the setback from the rear yard varied, but probably ranged from about 30 feet to 60 or 70 feet. So on the other side of that setback, meaning on the other side of the property line, are some row houses. One of the row houses has a swimming pool. And as a result of the construction on Pennsylvania Avenue, the swimming pool in the rear of the house on E Street saw significant structural cracks and some settling of the rear yard. I don't know that that would have been easily apparent, or what do I want to say, obvious to the permit official. Because as I said, there's a separation of maybe 60, 70 feet between the building on Pennsylvania Avenue and the rear yard of E Street. But the swimming pool was damaged, I think, to the tune of tens of thousands, if not $100,000 of damage. So that's kind of what this bill is trying to get at with, for instance, a vibration. The developer, well, in this instance, the developer might have done some vibration monitors, which I think confirmed that there was stuff going on, but as I said, if it's subjective, I'm not sure the subjective would have caught this.
Yes, I remember a little bit about that example you're talking about with the pool. I was not suggesting that vibration monitoring should be subjective. No, we want the code official, the chief building official, to have the discretion to require it, but not simply require it for every project. So that's sort of like our position. With the vibration monitoring, there are different levels of vibration that cause damage. Some happen to be just cosmetic damage. And I don't want to belittle cosmetic damage, but like having like a crack on the plaster from vibration, it's not the worst thing that could happen compared to like structural damage from like differential settlement. So by codifying the chief building official or the code official's authority to require vibration monitoring, we will have another tool to protect homeowners from damage. And if there is a progressive trend based off the increase in like the vibration intensity and velocity, then we would ask the developer to take more mitigating measures. So that's sort of like the spirit of our suggestion.
To go back to your insurance bill, would the property owners along E Street be protected? Or covered, I should say?
If the project owner, contractor, had coverage at that time for the adjoining and adjacent property, yes.
What about where an alley separates them? Would you would want at the other side of the alley, that would be adjoining or adjacent?
And that is where the flexibility in the language makes sense as it is currently written, based off risk factors, based off the chief building official determination that the nature of the construction, scope of work, and the area being impacted warrants the insurance coverage. Even when neighbor notification is not required, we want to be able to mandate the purchase of insurance to cover them in the alley situation that you're describing.
I think I got lost there. You would want the property on the other side of the alley to be covered.
Yes.
Give me a second. Anything else you want to add, Director?
Not to this construction management agreement, but from the various complaints that we've heard to the various hearings that Chairman you've held that deals with like property damage, we know the problem exists, and we know the current tools available leaves much to be desired in terms of protecting our residents and even contractors and property owners. The idea of this unique insurance product came about through research, talking to people, working with the industry to understand the gaps. So it is a light bulb moment for us and the city overall to see that there is a solution to helping people. And it's not going to be that expensive because this is not a concept. We've gone through the trial. We've gone through the research process. So I'm encouraged by your level of attention to this issue. I'm also pleased that you've focused on ways to help residents. So I ask the council to move expeditiously in making this proposal law so that we can strengthen protections for property owners and residents in the District of Columbia.
Okay, thank you. You're gonna try to get back on roughly how many permits would be or projects would be affected by this, by Bill 24-201. I can't remember if there was anything else you were gonna get back on.
Yeah, that's the main thing. My staff took notes as well, so I'll circle back with them to compare notes and make sure we can get back to you as quickly as possible.
Okay, thank you, Director.
Thank you, Chair.
Thank you very much, and thank you to the previous witnesses. As I indicated before, the record in this matter will be open for 2 weeks. That is, it will close at 5 p.m. on Friday, October 14th, 2022. Time is 1:40 in the afternoon, and this hearing is adjourned.